email and
they respond.
And then
Okay, good morning, everybody.
Good morning.
Good morning. For those of you who don't know me, I'm Cynthia Sadkin. I'm LAF's Director of Client and Community Services, and I'm one of the team members of the ADAPT project, which is, as you know by now, ADAPT is Advanced Directives and Property Transfers for Seniors. This morning, we are finally on to part 2, PT, which is property transfers for seniors. And we have with us again, luckily, Tom Wendt from the Center for Disability and Elder Law, who is our subject matter expert, who is going to teach us everything that we need to know to do property transfers for seniors, with the goal being that seniors could decide for themselves during their lifetime who inherits the property when they die. It's not inheritance, it's a property transfer, and they will not have to go to probate to do that. So we think that's a great benefit to our clients. We're here to promote it, provide the service, and help them with that and learn how to do it properly. So without further ado, I'm transferring over to Tom to teach us. Thank you.
Thanks, Cynthia. Again, my name is Tom Wendt. I'm the Legal Director from the Center for Disability and Elder Law. This is our 4th training in this project, and this one is specifically on the transfer on death instruments. We've done trainings previously on powers of attorney for property, powers of attorney for healthcare, and Illinois living will declarations. 2 weeks ago, we did one on all of this, and so now we're going to focus just on transfer on death instruments, or TODIs as they're called. A TODI is a document that can be signed by a homeowner owning residential real property, where they can record a beneficial interest in that property for purposes of avoiding probate upon the death of the homeowner. And this is sort of like what you would do with a land trust. This is an alternative to a land trust, and I'll talk about the differences between the two after I explain what a TODI is. It allows somebody to take what is, in most cases, their major asset out of the probate process by appointing a beneficiary who would be able to receive the property outside of probate after the death of the owner. It is only applicable to real property, which includes single-family homes up to 4 flats, condos, or, as we see so many of in Chicago, a single tract of agricultural real estate containing 40 acres or less. If only one of us owned 40 acres in Chicago, we all would be able to retire. And LAF would be funded indefinitely.
Tom?
Yeah.
Does the senior, if the senior happens to own, say, a small residential real estate as an investment property, can they transfer that with a TODI?
The answer to that is, according to the statute, it specifically says residential real estate from 1 to 4 flats. It does not require it to necessarily be the primary place of residence.
Okay.
That being said, I have not seen any litigation about that yet, whether or not it's limited to the primary residence. In some states it is.
Well,
In Illinois statute, it does not say one way or the other.
Okay. Sorry.
Because it says that an owner may transfer residential real estate by a TODI to one or more beneficiaries as owners concurrently or successively upon any contingency effective upon the death. So it doesn't limit it to the principal place of residence, at least under the statutory language. Once the TODI is recorded, and I'll get into the definitions and the recording requirements and things like that in just a minute, it's important to remember that a TODI is revocable by the owner. The owner has the right at any time to change her mind and revoke the TODI. Selling the property revokes the TODI. Although we do recommend, if someone is going to sell the property that is subject to a TODI, that they file a revocation first before the deed is recorded, transferring the property, just to make it clear that the TODI is being revoked. And that's also one of the great advantages of a TODI over a land trust, as I'll get to in a couple of minutes. In order to do a TODI, like in order to do a will or to do a power of attorney or to do a living will declaration, the owner of the property must have contract capacity to do so. It's the same level of capacity as would be required to draft a will. They must be of 18, they must be of sound mind, they must not be under any sort of force, coercion, or undue influence, and they must understand the nature of their actions. Other than that, they have the freedom to do this if they choose. Under a power of attorney, if somebody is an agent under a power of attorney, the agent does not have the authority to draft, record, or revoke a TODI. The agent does have the power to sell the property or transfer the property, but they do not have the power to do a TODI, which is a bit weird. And I think when they drafted the legislation, they simply didn't take that into consideration, that the agent has the authority to sell the property if it is in the best interest of the principal, but they do not have the right to do a TODI. The other reason that I think that is that an agent under a power of attorney for property does not have the authority to draft or revoke or execute a will. And considering that it's a property transfer as opposed to a probate action, it does have the same effect. And because the agent under the power of attorney for property has the fiduciary duty to protect the estate plan to the best of their ability, whatever plan may have been created by the principal prior to losing capacity, I think part of the theory might have been that they did not want their agent to be able to do something with a TODI that they would not be able to do with a will. I'm not sure about that, but it is a bit anomalous that they could sell the property, but they can't create a beneficial interest in the property. So what are the requirements? The requirements of a TODI are basically the same requirements as a deed. We'll look at the form in just a minute. It must be executed. Unlike a deed, it must be witnessed. And it must be acknowledged through a notary as well. So it has some of the same requirements as drafting a deed, signed, recorded, notarized, and some of the same requirements of a will, signed, witnessed. It must state that the transfer to the beneficiary is to occur upon death, and that's written into the template form. It must be recorded prior to death. A TODI is not valid if it is not recorded. And it must be recorded in the county where the property is located, which again, for our client, should be the recorder's office down the street. Failure to comply with all of the requirements renders the TODI ineffective. So it's really important that A, the owner of the property have the capacity to do this, B, that it be done properly, that's our job, and C, that the owner actually record. It doesn't do any good if it's not recorded. It must be executed and attested and acknowledged. Like a will, a TODI, it requires 2 or more credible witnesses, and that generally means 2 people who are not taking under the TODI, 2 people who are not agent or family members under power of attorney, and are not beneficiaries under a will. In my office, the way that we do it, we have 2 people from the office come in and serve as the witnesses. I imagine in this project we'll do it exactly the same way once we start drafting TODIs. And they must be notarized, as I mentioned a moment ago. as I mentioned previously, a TODI may be revoked at any time while the owner of the property is still alive and still has the capacity to do so. The revocation may be done by another TODI, which will revoke the previous one, or an instrument of revocation that is recorded. That's simply a document that says, I revoke the TODI, signed on this date, recorded with this recording number. Typically, the revocation will have the same formalities. It must be signed by a owner of the property who has the capacity to do so. It must be witnessed, it must be notarized, and again, it must be recorded. Interestingly, a TODI is not revoked simply by destroying the TODI. Simply by destroying the recorded document, that is not a revocation. Unlike, say, destroying your will be a revocation of your will. The reason for that is because it's recorded. If the document, same thing with a deed. If you record your deed and then you inadvertently destroy the deed, it doesn't revoke the deed. It's still recorded. It's still the public record. You simply go to the recorder's office or go on their website and print a new one. Same thing with a TODI. Simply writing revoked on the face of your TODI is not a revocation once it's been recorded. A provision in a will that says, I hereby revoke my TODI, is not a revocation because the TODI supersedes the will. Just like joint tenancy supersedes a will, just like a land trust supersedes a will, a TODI supersedes the will. So even if you write in your will, I recorded this TODI on this date, I left the property to my son, I hate my son's guts, I don't want him to have the property, he's not entitled to it, he still gets it, unless the owner revokes the TODI formally. Now that might raise a will contest, but that's a different story. Tearing up the recorded deed, writing a revocation, those are not effective. It must be, the revocation must be recorded. So what's the effect of a TODI upon the owner's life, during the owner's life? Well, first and foremost, it does not affect her ownership interest. She is still the owner of this property. It doesn't affect a mortgage. It doesn't affect a lien holder. She is conveying this property, this beneficial interest in the property, to the beneficiaries subject to anything else on the property, a mortgage, a lien, taxes, etc. It also theoretically doesn't affect the right of a creditor, secured or unsecured. That's a little bit different. I'll get into that in just a minute. Even if the creditor has notice of the instrument, which means that they should go ahead and try to enforce their lien if they have it. It doesn't affect anything involved in the beneficiary either. It does not affect the beneficiary's eligibility for public assistance because this is a beneficial interest only. Again, if we had taken this property and done a joint tenancy deed where we deeded the house from mom to son, that would affect son's ability to, say, get Medicaid if he has a disability or supplemental security income, etc. A TODI does not affect any of that because it's a beneficial interest only. It doesn't create any sort of legal or equitable interest in favor of the beneficiary, which means it's not subject to creditors of the beneficiary until that beneficiary accepts the property after the death of the homeowner. So if somebody is suing a beneficiary and they do a title search and they discover the TODI that has their name on it as a beneficiary, that has no effect at all upon the title to the property at that moment. Now, once mom dies and son takes the property and accepts the TODI and accepts the ownership interest of the property, then the creditor may be able to go after it, but not during the life of the owner. It's also important to remember that the owner can do anything with the property that she chooses while she still has the capacity. She can sell it. She can do a TODI today and sell the property tomorrow if she wants. Again, I recommend that they record a revocation of the TODI before they record the deed, but that's her choice. She can mortgage it. She can rent it out. She can do whatever she can continue to live there. She can take the tax benefits of being a senior homeowner. It does not affect her ownership interest at all. And again, that's also a key component of this. So we've done a TODI, and again, we're going to look at the form in a minute. We've recorded it, mom's lived the rest of her life, and then mom passes. So what happens next? Well, first, the beneficiary has the right to accept or disclaim the interest. If the beneficiary does not want the property, it's $50,000 underwater because the property was in foreclosure and mom hasn't paid her mortgage in 4 years, son can simply file a disclaimer. I don't want the property. I'm not accepting my interest. If he does accept his interest, then he records his interest. Again, if he does accept the property, it is subject to the mortgage, any other liens, or any other interest that the property was subject to at the time of the owner's death. Mechanics liens, tax liens, etc. It's still subject to those. Those still will have to be paid off. Just like if we had left it through probate, it would be subject to all of those debts as well, and those would have to be paid before the deed would be conveyed into the name of the beneficiary. Yeah.
So just to clarify, you said if the person wants the property, they have to record their interest?
Yes.
So they do a new document?
I'm going to show you the document in just a minute.
Okay.
It's called an acceptance of beneficial interest.
And you said that person would have to pay these things off in order to?
Yes.
Okay.
Well,
Or accept the
in order to
mortgage.
perfect their interest, yeah.
Okay.
Because if they accept it and they don't pay off the mortgage,
Still knows.
the lender's going to foreclose.
Mm-hmm.
So better that they accept it, refinance it, pay off the mortgage first before it being subject to a foreclosure action.
Okay.
TODI does not trump joint tenancy or tenancy by the entirety. But if a property is owned in joint tenancy or tenancy by the entirety, it doesn't preclude the owner or owners from drafting a TODI. But what would happen is it would only fall to the beneficiary after the last joint tenant or spouse, in the case of tenancy by the entirety, passed away. So if husband and wife own the property and they want to do a TODI leaving it to their son, it would go from spouse A to spouse B. Upon the death of spouse B, it would go to son. That's when the TODI would be effective. If they don't want it to be effective that way, then they need to deal with the joint tenancy situation while they're both still alive. Yeah.
So I don't want the property to go to my son, but my husband executes a TODI. He predeceases me, I get it.
Yes.
And is there anything I can do to prevent him from getting it, my son from getting it, or am I bound by that TODI that he executed?
No. You're not bound by it because you didn't execute it. Essentially, the TODI goes away because he predeceased you.
Uh-huh.
Now, I would probably recommend as sole owner of the property, and you absolutely don't want your son to have an interest through the TODI, then you'd want to record a revocation
Okay.
at that point.
So when you're talking about.
Now, if you then passed away the next day, he would get it by intestate succession, or at least a portion of it, but that's a different story. But if, in the scenario that you said, where your spouse records the TODI that says, I want my interest to go to my son, the joint tenancy or tenancy by the entirety, however you and your spouse own property, would trump that.
Okay.
If, on the other hand, your spouse owned the property solely and said, I want the property to go to my son, and records the TODI, then the son would get it. Because the TODI trumps intestate succession, but not joint tenancy or tenancy by the entirety.
Okay.
Okay?
So you're talking about, does not trump joint tenancy, you're thinking more about where people jointly execute one, husband and wife jointly execute a TODI for
Right.
their son?
Or
Okay.
in the scenario that you said where the property is owned jointly and one spouse executes the TODI. We've run into that a couple of times, and so we sit down with our clients and we say, no, if you do this, it's still going to go to the spouse first or the other joint tenant first. And we want to make sure that they're aware of that the TODI is only effective essentially if the other joint tenant predeceases.
Right.
Unless they both sign off on it, yeah.
I thought a joint tenancy can be broken and creates a TIC,
Right.
tenants in common, if you execute something giving up your interest.
Right, but this is not giving up your interest. This is
It's a future interest.
this is a future beneficial interest only. If you, changing the hypothetical slightly, husband and wife own the property, husband deeds his interest to son now, that would break the joint tenancy. If it was in tenancy by the entirety and husband deeded his interest to son, that would be a void transaction.
Right.
That would have no effect whatsoever. But if one joint tenant deeds their interest, that breaks the joint tenancy and creates a tenancy in common between the new owner and the former joint tenant. This does not do that because it's a beneficial interest only.
Okay.
But I'm glad that you brought that up because that's a really important consideration, yeah.
So can joint tenants or tenants by the entirety sign a TODI together?
Yes.
to grant- okay.
Yeah, and the way that it's written is it will say, upon the death of the last joint tenant or the survivor of us, in the case of tenancy by the entirety, then it goes to whomever, the beneficial interest. That's very common. If we do the TODI, the owner dies, then the beneficiary records their notice of death affidavit and acceptance of the property. That also must be recorded. You must have the death certificate in order to record that as well. And once it's recorded, the beneficiary becomes the record title holder. It's that simple. It takes a matter of minutes to do this, assuming there's no mortgage or liens on the property. And as I mentioned a few minutes ago, a beneficiary can disclaim their interest if they want, and they would record a disclaimer. I hereby disclaim all interest in the property. That normally happens again if there are substantial liens on the property, it's underwater, the beneficiary simply doesn't want the property, in which case it would fall into the estate of the owner if in fact the probate was ever opened. Yeah.
And if probate was not open, and you've got like a piece of badly polluted
I like that.
property, and nobody.
Do you mean legally polluted or do you mean actually polluted?
Legally polluted.
You have an old gas station,
Okay.
the
Oh,
beneficiary
it
doesn't
could
want
be
it.
shades.
You couldn't do a TODI with an old gas station because it can only be residential property.
Okay, residential property that was built on an old gas station.
Okay.
That hasn't been cleaned, I mean, there's underground tanks under lots of houses. there's leaking underground storage tanks.
Okay.
Whatever. What's the status of the title if the beneficiary disclaims and there is no estate opened up from the?
Well, under the Intestate Succession Act, if there is no beneficiary to the property, real property escheats to the county and personal property escheats to the state.
Okay.
That being said, the county isn't going to want this property either, because they're not going to want to bear the burden of doing this cleanup if necessary. So they may try to find somebody to take it. A beneficiary, as I mentioned, is subject to the claims of creditors and any statutory claimants, like the state if necessary, just like any other non-testamentary transfer. TODIs can be contested. If they're going to set aside, if someone's going to file an action to set aside or contest the validity of a TODI, it has to be commenced within 2 years of death or 6 months after probate is open and letters of office are issued. That would be a situation where somebody is contesting whether or not, say, the owner had capacity to sign the TODI when she signed it. That would be done, it's the same requirements as contesting a will for most purposes. But if there's a purchaser or mortgagee for value and they enter in their note into the mortgage without notice of a lis pendens, then they can issue their mortgage free and clear of any contest.
Say that again?
Yeah, I don't
Sure.
understand that.
Somebody takes the property through a TODI,
Okay.
and then they finance it. The mortgagee issues the mortgage without notice that there's a contest.
Because no contest has been filed.
Because
in
no
court.
contest has been filed, or because no lis pendens has been recorded. And typically, whenever there's a dispute over property, a foreclosure for instance, the first thing that gets recorded, or that gets filed, is the actual action, the foreclosure action. Immediately thereafter, a lis pendens is recorded with the recorder's office, thus making it a public record that there is a dispute related to this piece of property. If we were doing a quiet title suit, we would have the right to do exactly the same thing, to record the lis pendens, which clouds title for purposes of during the pendency of the dispute. So if the challenger either doesn't file their challenge in time or doesn't record a lis pendens, thus making it a public record that there is a challenge, the mortgagee is not affected by that.
So a lis pendens is a recordation that there is a dispute.
Yes.
And
Yes.
it's not filed through the court's office, it's just filed at the recorder?
It's recorded at the recorder's office. The easiest one to describe is in a foreclosure. When a foreclosure happens, the lender or the lender's counsel will file the complaint and will have their lis pendens immediate at that point. The judge will say, okay, you can go ahead and record that. It's been the complaint has been properly filed. Then they go over to the recorder's office and they record it immediately, usually the same day.
Do you have to have a court order or
No.
a court, so someone can cloud title any old way just by filing a
people
lis
can,
pendens?
yeah, I mean, people can cloud title any way they want by filing fraudulent documents, but they're in the recording statutes, that's fraud, and they can be liable for that. In the case of a lis pendens, it can't be until after the case is filed, because the file number of the court case is included in the lis pendens.
Okay.
So like we do a lis pendens if there's a divorce proceeding going on.
Right.
And there's real estate included in a
Yeah.
divorce to say, don't go selling the property during the pendency
Right.
of the divorce.
Or if there's a dispute over ownership between two owners and we're doing a quiet title suit, we'll file a lis pendens immediately to make sure that the defendant doesn't go and sell their property right away. We'll do that in adverse possession cases, etc.
Got it.
This has been a bit of a problem with title insurance companies because they've questioned whether or not the property being acquired by TODI can be sold immediately before there is a before there's any sort of clear deed of the title. The way that I've dealt with that is I've simply had the title company issue a title indemnity for it, and that they're insuring over any sort of contest. I've only had one of those in the, I don't know, 100 or so TODIs we've done at Seattle. Drafting a TODI is similar to drafting a deed. And remember, there are 5 important things to consider. Capacity. It's vitally important that the owner have the capacity to execute the TODI. All of the information must be correct on the TODI. That includes the property identification number, the legal description, the property address, and the ownership interest. We can't do a TODI for somebody who doesn't actually own the property. And I know that sounds obvious, but we run into situations where we've had multi-generational families where mom owned the house, kids lived there, mom died, nobody bothered to do anything about clearing the title, putting it into the kids' names, even though they had an intestate succession interest. Those kids cannot do a TODI until they are actually in title to the property. They may have been entitled to the property through intestate succession, but until they are actually in title, they can't do a TODI. You can't convey an interest you don't have. And the only way to perfect that interest is to record whatever, their deed in lieu of probate, or their affidavit in lieu of probate, or if it's a joint tenancy affidavit, etc. So it's really important when we're doing a TODI that any of those issues are cleared up prior to us doing the TODI. And also, we have to make sure that it's been properly executed. Signed by an owner who has capacity, witnessed by 2 competent witnesses, and notarized, which again shouldn't be a problem. And then finally, it must be recorded in order to be effective.
Question?
Yes.
Is it sufficient to confirm information through the online county recorder's office?
That's the way that we do it. What we do is, prior to drafting the TODI, we will do sort of a basic title search.
Mm-hmm.
We'll go to the assessor's office, we'll go to the treasurer's office, look at the status of taxes, and then we'll go to the recorder's office to pull whatever the most recently recorded deed or mortgage release, etc., to make sure that we have the legal description correct, the PIN correct, and the ownership interest correct.
So you actually go to,
No, we do it online.
you do it online?
Yeah.
And second, for recording, is there any kind of a way to pay for that? With that?
Yeah, the owner of the property pays for that.
The client pays.
And it's usually about $55,
Okay.
depending on whether it's 2 or 3 pages. And whether it's 2 or 3 pages really depends on how long the legal description is, whether we can fit it in the open paragraph space, or whether we have to do it as a 3rd page. Which brings me to a concern that I have. I don't see that the actual form is up here.
It's in
Okay.
You guys have it. Okay, good. I don't have it though. I will put that. Okay. When I came in, I had to pull the PowerPoint off of my email, and I had included this as well. So I'm going to do this by hand.
Okay.
So thank you for handing this to me. This is the actual TODI. It is a very simple document to complete. We put the name and address of the taxpayer. We put their name and their marital status, just like we do on a deed, because we want to make sure that there aren't some homestead issues that could potentially be related to this. What their address is, that they're going to be transferring the property upon their death. Then we identify the property by street address, PIN, and legal description. If we can fit the legal description in this little blank space, we do. If not, we put it as a separate page. And then we describe who's going to be the beneficiary or beneficiaries. We are allowed to do a TODI to multiple people. If our client has 2 children and she wants to leave the property to both of them, she has the right to do that in a TODI. We do have to ask whether she's going to want them to take as tenants in common or as joint tenants. If they are taking as joint tenants, it must be equal percentages. If it is tenants in common, it can be unequal percentages. We could leave 75% to one kid and 25% to another kid. That may cause a fight amongst the kids. That's their problem, not ours. But if it's going to be joint tenancy, as you know, because of the 4 unities of title, it must be equal ownership. Upon my death, I transfer my interest in the above described property to the beneficiaries as designated. This instrument revokes any and all prior TODIs made by me. Before my death, I have the right to revoke this instrument, and it is to be recorded prior to death. They sign it. It is witnessed by 2 competent witnesses, and it is notarized. That's the document that gets recorded. Yes?
You mentioned they can assign a beneficial interest as joint tenants or tenants in common. What about a successor beneficiary?
You can do successor beneficiaries as well. You can say, I leave the property to my son as beneficial owner. Should my son predecease me, then it's going to go to my granddaughter.
Okay.
Assuming that all of the beneficiaries would have the capacity to own property, you know, that granddaughter isn't 3, that she's over the age of 18, you could do that as well. You're allowed to leave successor beneficiaries or named successor beneficiaries under a TODI.
Tom,
Yeah.
when you said if the legal description doesn't fit here, that you can add a page, would you say see attachment?
See Exhibit A, see attachment, see legal description attached. Yeah. And that's the way that we often do it, because it is incredibly important that the PIN and the legal description be exactly correct. If it is one number off, if it was lot 4 instead of lot 3 in the legal description, you conveyed someone else's property. We do not want to do that. Now, it's easy fix, and it happens all the time. Before I came to Seattle, I did investment and commercial real estate for several years, and I still do a fair amount of real estate on the side. And it's amazing how often, you know, the legal description is wrong. You know, I'm representing a buyer, and suddenly the legal description doesn't match the title. It's an easy fix, but the best way is to avoid it from happening. Make sure that it is letter perfect.
I have a
Yeah.
question. Back on the successor beneficiaries. So let's say the son does live longer than the mother, gets the property. Does the second thing about the granddaughter, that goes away?
That goes away,
Okay.
yeah. Once the beneficiary records Glad that you said that.
Mhm.
The other document that's in your packet, which is the Notice of Death Affidavit and Acceptance of TODI, once this is recorded, anything else in the TODI is extinguished. This document is the document that the beneficiary would complete and record when the beneficiary is ready to accept title. We include it in our packet of information when we help our clients, but it's basically primarily left blank. We might put the owner's name in there, the beneficiary's information where it says mail to and name of address of taxpayer, but the rest of it, blank died on what day? Well, we don't know yet because the person is still alive. So that's going to be completed after the death. Legal description we can include, the address we can include, the PIN we can include. The next document that the transfer and death instrument dated blank and recorded as blank, we leave that blank as well, because we don't have it recorded yet at the time that we sign it. So that's something that the owner could fill out if she wanted to after she recorded, or it's usually done as part of the acceptance. They go back to the recorder's office, they look at the date that it was recorded and what the recording number is, and they fill that information in. And then who are the beneficiaries? And then the rest of this is left blank because it only is signed upon the acceptance. In witness hereof, the undersigned beneficiaries hereby accept the transfer of residential real estate under the TODI on that particular date, the date that they're signing it. So we don't want them to sign it, even if they're there. We don't want them to sign it until they're ready to accept. I've had a couple of situations where the client has come in, we've signed the TODI, the beneficiary has come with, and they want to sign this immediately. It's like, no. First of all, you're not accepting it. We don't know whether you're going to accept it. We don't know what's going to happen in the next 5 or 10 or 15 or hopefully 20 years before mom dies. So never have them sign this. First of all, it doesn't have any effect yet. And second of all, we don't want them signing a document that isn't complete. And then that is notarized as well. And then this must be recorded to finalize the transfer after death from the owner, the now decedent owner, to the beneficiary or beneficiaries. So it is as important that they sign and record this as it was that this be signed and recorded. Yeah?
Is there a time limit by which the beneficiary needs to complete and record the notice of death?
Under the statute, I want to say it's 6 months, but I'm not positive. This is so...
TODI itself?
The acceptance of the TODI.
Of course it's-
Yeah, I believe it's either 90 days or 6 months, but I'm not positive. These are very, very new. TODIs have only been around in Illinois since 2012.
Yeah.
They've been in other states for many years, so there isn't very much litigation about it. So if somebody recorded their acceptance a year later, there's no litigation, that I've seen at least, there's no litigation on whether that would be valid or not.
So if the beneficiary chooses to essentially just kind of sit on this, is the property essentially just in limbo, or?
Well, the problem with doing that, the problem with doing that is that the TODI is already recorded. The beneficiary is already named. The beneficial interest is already described. For the beneficiary to just sit on it would cause sort of a legal problem. Because by recording the TODI, you're taking the property out of the probate process. So if probate has been opened on everything else, but the acceptance hasn't been recorded, or disclaimer, if they're disclaiming, hasn't been recorded, it puts the status of the title to the property in, to use your term, in limbo. Because technically speaking, nobody is the owner of this property at that point. I guess we have 10 minutes left. Because the owner is still the owner of the property until some transfer has happened, and that's common in all areas. So technically speaking, she's still the owner of the property, but there is this beneficial interest that's already been that's this naming of a beneficiary, and this beneficial interest has already been recorded. So she has subsequently passed away. So that makes it a little bit more complicated in terms of being able to do anything with the property. So they really need to do something, either accept or disclaim very quickly. Because if they don't, then that's just going to clog up the entire probate process. Because if they disclaim, then it falls into the residuary estate and goes from there. If they accept, then it takes it out of the probate process completely and they get the house. So whatever it is that they're going to do, it's incumbent upon the beneficiary to do something sooner rather than later.
Could this form be used as a disclaimer form if you just wrote,
No, they would want to do a form that specifically says they are disclaiming. It would look very similar. Yeah, but it would say sort of notice of death affidavit and disclaimer of TODI. And then it would say, I hereby disclaim my interest. But simply crossing out accept and writing disclaim probably wouldn't be sufficient. We'd want a separate form. Yeah.
Well, two questions. As far as this getting the beneficiary to move quickly, I wonder if would it be permissible or advisable to put something in the durable power of attorney for property, mentioning that there is a TODI and what to do, and giving the agent the authority to talk to the beneficiary?
The problem with doing that, you could do that, and while the principal of the power of attorney and the owner of the property was still alive, have the agent contact the beneficiary and say, mom's gonna pass away, make sure that you do something. But once mom passes, the power of attorney for property by law is automatically terminated.
Right, so the best thing I suppose is to have the principal tell the beneficiary this is out there, just like you.
Exactly.
It's good to have the beneficiary tell the principal in a will.
Right. The way that we do that, by the way, is we write in, when we draft a will for somebody and a TODI, we put in the property identification section, I own this property at this address, it is subject to this TODI, which has been completed, and is to be recorded and made a public record. I hereby direct the executor to notify the beneficiary upon my death. And then we don't mention the property again in the rest of the will, because it's no longer a probatable asset. But it at least alerts somebody that this has to happen at some point or another. Because to get back to your question about if the beneficiary doesn't know what to do, even though we've given this document and partially completed it when we did the TODI, that might have been a year, 2 years, 5 years, 20 years ago. Who knows where this is now? If they don't know what to do, then it's hard for them to complete their interest.
What happens if there's more than one beneficiary and one accepts and the other one doesn't act?
They all have to accept.
Simultaneously on the same instrument?
They all should, yes, because if you look at the acceptance, in this case there are 2 beneficiaries and there's two execution spots. They all should do this collectively. If one does it and tries to steal the property out from the other, that's just going to cause a quiet title suit anyway. Because I would argue, depending on who I was representing, if I was representing the beneficiary who did not sign and record, I would argue that was an ineffective acceptance of the ownership. If I was representing the person who did sign and record, I would probably try to settle that very quickly by allowing them to record their own re-record the acceptance with everybody's signature. but legally speaking, they should all sign it at the same time. Yeah, 2 more questions.
Is
Oh,
there
yeah.
an issue, sorry, is
No,
there an
please.
issue if there are multiple beneficiaries, but it doesn't designate in what shares are taking? Is there like an ineffective TODI, or is it presumed like an equal split?
That would be bad. That would be bad document drafting on behalf of the drafters, which shouldn't happen here. My argument is that the law would probably imply a 50-50 split, and if we said that they were taking as joint tenants, it would have to be under the four-tenancy of title. It would have to be equal, but really we should designate that. Yeah.
All right, I'm sorry to bring this up.
Please.
What do we do if it's a condo? This seems to be really set up as a single-family home. Toady, is there a different form for
No.
a condo with all of the stuff that goes with the? I mean, legal descriptions in condo documents are insane.
They can be several paragraphs, in which case we would just do it as an attachment. But under the TODI Act, there's no difference between conveying a single-family home, a townhome, or a condo.
Okay.
However, the beneficiary is going to take subject to whatever the condo restrictions are.
Right.
So, they're going to be responsible for picking up the assessments from that moment on. If there are any back assessments, they're going to be responsible for paying those. If mom was involved in litigation with the condo association, they're going to have to resolve that, etc. So they're going to take subject to whatever the condo is subject to. If there's special assessments, they're going to take subject to that, etc. But in terms of the actual transfer, there's no difference.
Okay.
It's exactly the same acceptance, although usually, as you point out, a much longer legal description. Yeah.
What if the wife wants to execute a TODI of her non-marital property to her husband, and then they get divorced? Does the fact of the divorce eliminate the TODI, or is the TODI
That's a really, really interesting question. Because under the Wills Act, if you name your spouse as a beneficiary to your will and then you subsequently divorce, the legal fiction is it is as if the spouse was deceased as of the date of judgment, or legal separation in the case of a legal separation. So anything that they would receive under the will would go according to fault of the residuary or whatever you declared to be the successor beneficiary. Under the Power of Attorney Act, if you name your spouse as your agent under your power of attorney and subsequently divorce, the legal fiction is exactly the same, that your spouse deceased as of the date of the divorce, so it would fall to any successor agent. The TODI Act, to the best of my knowledge, does not list anything about that at all. However, I would strongly suggest that if you do a TODI and the person is married and they are conveying the property to their spouse and subsequently divorced, that they do a revocation immediately. I would, if I were litigating that, I would use the Will Act as because this is similar to a will and is intended to be done in lieu of a will, that the same criteria should apply to the case of a divorce, that it becomes that the person is deceased as of that date, that they can't take under it, et cetera, et cetera, et cetera. But I would strongly recommend doing the revocation immediately.
Mm-hmm.
But that's a really interesting question, because it's something that the drafters of the statute didn't put into the statute, where they did put exactly that language in both the Will Act and the Power of Attorney Act.
Mhm.
Yeah.
I have a question about a guardian if you have a guardian appointed, are the same restrictions put on the guardian as would be on an agent under power of attorney?
Good question.
What do you mean by restrictions? Can a guardian do a TODI?
Yeah.
No.
Yeah, okay.
No. Just like a guardian can't sign a will.
Okay.
And now they've amended the Will Act as of this January to say that there is a presumption that somebody who is under a guardianship automatically lacks the capacity to sign a will.
Interesting.
And I would argue if they lack the capacity to sign a will, they lack the capacity to sign a TODI.
Mhm.
And there's nothing in the Guardianship Act in Section 11A of the Probate Code that allows a guardian to sign a will. So I would argue that they can't sign a TODI. It did put in the TODI Act that a power of attorney can't. I would argue it's exactly the same for a guardian. And I saw one more hand in the back. Yeah.
Well, yeah, I guess my only remaining question is recordation sufficient notice to the mortgagor and lien holders? Or do you have to send a copy, does your client have to send a copy and let them know?
No.
Your client being the senior homeowner and they're doing a TODI for a property that's subject to a mortgage. I would argue that I would argue that the recording is sufficient because it makes a public record and it makes record notice. And I don't see that there would be any benefit to anybody to send them a copy of the recorded TODI to the mortgage company.
Just
it's not a conveyance. If, say, we did a joint tenancy deed and we took the property from mom's name and put it in the name of mom and son, that should be, the mortgage company should be notified of that. Because depending on the way it was written, that may or may not be a breach of the mortgage. But in the case of a TODI, it's only a beneficial interest, so there's no need to notify the mortgage company. The last thing that I wanted to mention, which I started at the very beginning, is, and to wrap up, is the difference between a land trust and a TODI. The underlying concept of the avoidance of probate is the same for both. You put the property into a land trust and you name yourself as beneficiary and you name your kid as successor beneficiary. When you pass away, the successor beneficiary can direct the trustee to convey the property to the successor beneficiary or keep it in the trust or whatever they want to do. It takes it out of probate for probate purposes. It's a non-probatable asset because the owner is not the legal title holder anymore of the property. The land trust is. We all know that. We've all taken estates and trusts. The TODI has the same benefit in the fact that it takes the property out of the probate process. The difference between the two is that in a land trust, you are not the legal title holder to the property anymore. So there's an additional benefit to a land trust, and that is the protection, the limited protection from creditors. If you're the owner of the property, you put it in the land trust and you are personally sued, they can't go after the house because you don't own it. The trust does. Yes, there are ways that they can break that, and I have fought a bunch of those with the city where there have been city liens for properties in land trusts. But in general, that's an additional protection. That does not occur in a TODI because you are still the owner of the property until death. On the other hand, having your property in a land trust can make it a little bit more difficult in certain circumstances to refinance the property, to convey the property, particularly if you put the property into the land trust and you name yourself and your kid as the beneficiaries, as co-beneficiaries, not beneficiary and successor beneficiary. If mom does that and she names herself and son as beneficiaries and then tries to sell, the trustee has the right, because they have a fiduciary duty, to both beneficiaries say, hey, you can't sell this property and move to Florida because we have to protect both beneficiaries. In a TODI, none of that applies because she's still the owner, and putting the TODI, naming the beneficiary, does not do anything to affect her current ownership of the property. So she can do a TODI today and sell it tomorrow if she wants. And then finally, it doesn't affect her ability to refinance, to lease, things like that. Whereas if it wasn't a land trust, that may be a concern. And then finally, if you go and put your property in a land trust and you go to, say, Chicago Title and Trust, they're going to charge a fee
Annually.
to set it up and to maintain it. And it's usually about $125 a year. The TODI, the only cost is the cost of drafting it, and by law, only the individual homeowner can draft her own TODI, or a lawyer can draft it. A trust company and a non-attorney estate planner, a real estate broker, they are not allowed to draft a TODI. It has to be a lawyer or pro se. And so the cost of drafting it, for those, if you were doing this in private, of course we're doing it pro bono here at LAF, the only other cost is the cost of recording, which again is about $50 or $55 depending on whether it's 2 or 3 pages. That's it. There's no ongoing cost. So the long-term expense of a TODI is significantly less than the long-term expense of a land trust. So, final question.
Or comment, and
Okay.
correct me. My understanding is also now with Chicago's requirement for water certs and all this other stuff, that if you were just merely to add somebody to your deed and record it, you have to pay some more money. Whereas the TODI you don't.
We have run into that, where we have done a couple of times where we've broken joint tenancy, where the 2 joint tenants were conveying the property back to themselves as tenants in common because they wanted to be able to convey it, their interest, to whomever they wanted in a will or what have you. And yeah, you are still required to do the municipal requirements. You're not required to pay the transfer stamps because it's a gratuitous transaction, but there is additional paperwork involved. Good point.